This is Hubwonk. I'm Joe Selvaggi. Welcome to Hubwonk, a podcast of Pioneer Institute, a think tank in Boston. It has been said that each new justice is a new court. As the 2022 Supreme Court term winds to a close, the first term to include all three former President Trump's nominees, court watchers, policymakers, and concerned citizens have new information about how each of the 9 justices apply the 230-year-old U.S. Constitution to modern legal disputes. Indeed, each court decision exposes the tension that arises between a constitutional democracy's power to enact laws and the constraints imposed when those same laws must comport with constitutional principles. To observers, it can be a relief when the court's majority limits legislative prerogatives that they do not favor, but unsettling when the court strikes down laws seen as necessary for our modern polity. Nevertheless, each case reveals the complexity and nuance of each justice's view of their role in the process. What has this term told us about the philosophical makeup of this court? How do the most recent high-profile decisions reveal each justice's views? And what does the court's makeup suggest about how it may rule in the future? My guest today is legal scholar, author, and senior fellow of constitutional studies at the Manhattan Institute, Ilya Shapiro. His new book, Supreme Disorder, Judicial Nominations and the Politics of the Nation's Highest Court, just released in paperback this week, looks at the controversies of past courts and their decisions. Mr. Shapiro will share with us the way in which individual philosophies influence justices' decisions, how the cases in this current term reveal the views of the 9 justices, and what those views will likely portend for the court's future decisions. When I return, I'll be joined by constitutional scholar Ilya Shapiro. Okay, we're back. This is Hubwonk. I'm Joe Selvaggi, and I'm now pleased to be joined by author and senior fellow on constitutional studies at the Manhattan Institute, Ilya Shapiro. Welcome back to Hubwonk, Ilya.
Good to be with you, Joe. A lot's happened since we last talked.
Indeed, it has. I don't want to dwell on the past. We're always looking forward, but there's 2 big pieces of news just this week. One, of course, is that you are now a brand new member of the Manhattan Institute. Congratulations on that. The other big piece of news that I'm sure our listeners are interested in is that your wonderful book that we discussed in an earlier episode, Supreme Disorder, Judicial Nominations and the Politics of America's Highest Court, just came out on soft cover. Yep. So paperbacks,
very soft.
Plugging the show. It looks good. It looks bigger for our listeners who already bought the hard copy. Is there any difference with the new paperback?
Yeah, so I caught some typos. That's always good to do. And I added an epilogue, about 3,000 words on, what's happened since the hardcover came out in the fall of 2020, which is 2 more justices, Amy Coney Barrett and Ketanji Brown Jackson.
Indeed, a lot has happened, perhaps not a whole new book's worth, but a lot certainly to talk about. So let's jump into, we want to do a around the world sort of a review of what's happened in this past term. Everything's been decided now. We closed the book on this term. So let's do a little recap and start at the beginning. I want to talk about judicial philosophy, specifically as it pertains to the 9 justices that we now have, including Breyer. We're not going to talk about Ketanji Brown Jackson just yet. But before we jump into the cases themselves that were decided, let's define some terms for our listeners who are not constitutional scholars, ones that have been thrown around in the wake of the decisions. Specifically, what is what people call an originalist? What is what people call a textualist? We also have heard the word institutionalist. And finally, what I would call broadly consequentialists. So let's start at the beginning with, let's say, originalist. What does that mean?
Originalism is a method of constitutional interpretation that looks at the original public meaning of a constitutional provision. That is, the original Constitution, the powers that are granted to Congress, that was ratified in 1789. So what does the power to regulate interstate commerce mean? When it was ratified in 1789. We look at the Federalist Papers, we look at contemporaneous dictionaries, we try to figure out what those words mean. Or the 14th Amendment, obviously much in play this term, the meaning of due process of law, the meaning of equal protection. What did those words mean when the 14th Amendment was ratified in 1868? So It's not trying to get into the head of James Madison or Thomas Jefferson and what would they have thought of violent video games or something like that. It's looking at the words on the page, trying to understand their original public meaning. And look, originalists can disagree, just like historians can disagree about how to interpret certain events in our history. That's okay. Both judges and academics can have a lively discussion, but that's what originalists try to get at. Textualist is a related interpretive method that's applied to statutes. So we focus on the text of the Clean Air Act, say, that was at issue in one of the big cases this term. And so when that was passed in the 70s, when it was amended in the 90s, what do those words on the page mean? Again, not what Congress or the sponsors of the legislation intend, not what someone might have understood it to mean. They could have been wrong, but what do the words on the page actually mean? What does the text mean? And then you get to institutionalist, which isn't a method of interpretation so much as an approach. And so John Roberts, the Chief Justice, is often called an institutionalist because he operates not primarily at trying to get at what the text means necessarily or the original public meaning of a provision is, but he wants to preserve the institutional reputation of the court, and so might want to move not as quickly as some of his other colleagues that say, I'm just going to interpret as I see fit and let the chips fall where they may. Roberts tries to be a little cagier, maybe narrower in what kind of opinions he writes. And so an institutionalist cares about the institution. For that matter, it doesn't have to be just the court, could care about the institutions in general, Congress, the presidency, maintaining those big things rather than a focus on the words on the page. And finally, consequentialist, or sometimes related, might be a pragmatist, looking at the consequences, the result of a particular holding, of a particular ruling might be. And either with a view to not rocking the boat too much, either with a view of, not costing the government too much money, not disrupting society in some ways, or in any event, weighing those practical concerns in some measure, not exclusive to everything else, but that's a significant part of what that kind of jurist cares about.
Indeed. So you've laid that out very clearly. Before we get into how each justice ruled on every case, is there a single continuum on which you could map each of the justices? Well, we're often talking about liberal or conservative or Republican and Democrat. Is there a continuum, or is it more a scattershot? There's so many dimensions of the way a justice can look at a case that it doesn't really map to what we would consider political preferences.
Yeah, I think it's too simplistic to talk about a spectrum or even a three-dimensional spectrum, because there's more than kind of three axes on which one can look at the justices or can any judge's methodology in terms of the practical outcomes of their votes. We can talk in shorthand, and we do talk in shorthand about liberals and conservatives. That's unfortunate because I don't think any of them make decisions based on trying to implement liberal or conservative policy preferences. That tends to end up as the case for the most politically salient controversies. But it's shorthand that can be useful in talking shortly. But I would certainly not want the public to generally think of them as junior varsity politicians. Ideologically, let alone in terms of partisanship. I hate it even more when people talk about the Republican justices or the Democratic ones. I sometimes talk about the Republican appointed justices or the Democratic appointed justices, which is again somewhat useful shorthand because that's often relevant and increasingly relevant in modern times because the parties seem to have adopted divergent theories of interpretation. But still, the reason why you're interviewing someone like me is to drill down beyond the shorthand that you can in like a tweet or a short Associated Press story about the news of a particular case.
Indeed, you are careful when you in your writing, in your books, and your articles to discourage lazy thinking and reducing everybody to through the political lens. So let's again, by way of background, let's start with some history of how we get rights. We like to think of ourselves as a rights-based society. Those rights, foundationally, if we're talking about the Supreme Court, they're looking to the instantiation of those rights. I hope you'll agree that that starts with the Constitution. So let's talk about, we often refer to the first 10 amendments as the Bill of Rights, which by my reading are so-called negative rights or natural rights. Those are the rights we can't have taken from us. Describe for our listeners, what are we talking about when we talk about fundamental rights or those rights in the Bill of Rights?
Well, those are separate questions in a sense. The legal scholars talk about enumerated rights, which just means listed rights. The first 8 amendments say, the First Amendment, speech, religion, right to petition, right to assemble, Second Amendment, right to keep and bear arms, etc. But the founders were careful to add a 9th Amendment that says that the enumeration of these rights is not to deny or disparage others that are retained by the people. And so to the extent that modern jurisprudence, and we'll get into this a little bit because that matters in how Dobbs, the abortion case, and Bruin, the Second Amendment case, were decided, to the extent that we, think that unenumerated rights, those that aren't listed in the first 8 amendments, are somehow secondary to the ones that are listed. That's clearly not what the original public meaning, nor the original intent of the framers would have been. We talk about fundamental rights in a legal sense, not in kind of the lay conception of what is fundamental, what's basic, what's most important, but in the legal sense, because of the way that the jurisprudence has evolved over decades, specifically for unenumerated rights, those that aren't listed, courts often ask, is a given rights claim, is that based on something that's fundamental, or is it ancillary? Is it not a core right that we have under the Constitution? I don't think that's quite the right way to look at it, because there's no indication that when the framers were instituting their the constitutional provisions, or especially when the framers of the 14th Amendment, the post-Civil War amendments, were looking to protect rights. They could have, they had the English language, they had the terminology, they could have said these are the fundamental rights. They didn't do that. The 14th Amendment speaks of due process, privileges or immunities, equal protection. They could have just said the first 8 amendments are now applied to the states, but they didn't. They spoke in these other terms. So the modern jurisprudence has gotten away, I think, from the original public meaning of rights protections. But nevertheless, going back to the 30s in a case called Caroline Products, the famous or infamous footnote 4 does bifurcate rights effectively into fundamental and non-fundamental ones. And that's why, especially with unenumerated rights claims, rights that aren't explicitly listed in the first 8 amendments, that's what jurists tend to think about is a particular claim involving a core or fundamental right.
So the Constitution establishes enumerated rights, lists them, and then says in the 9th, there are other rights that are not here, but nevertheless are rights as well. You mentioned the 14th. I want to go a little bit deeper on that because it does have influence on some of the decisions that came down this term. I'll read it. My favorite part of the 14th Amendment is from Section 1, a quote, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive a person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the law." So effectively, as you mentioned, it says that these liberties or these rights that start or that are protected by the Constitution at the federal level also apply to the states. Say more about the fact that reading more deeply, for myself, I discovered both. It means that states can't infringe on rights, but also it has a affirmative obligation to protect rights as well. Say more about this. Of course, the 14th in the wake of the Civil War and the stain of slavery, but that's the context. But say more about what that means.
The original Constitution only protected us against the federal government. The Bill of Rights only protected us against violations by the federal government. That's why the post-Civil War amendments, the 13th that outlawed slavery, the 14th, which you just read, and the 15th, which prohibited racial discrimination in voting, that's known as the second founding, because it fundamentally reoriented, restructured our constitutional order such that an individual could go to federal court to enforce his or her own individual rights against state violation. That was an innovation. So the 14th Amendment says that states can't violate your due process of law or equal protection of the laws or privileges or immunities of citizenship. Again, that was a revolutionary type of thing. It restructured fundamentally our constitutional order. And so, when we're talking about most of the so-called culture war issues or rights claims, whether it's abortion or guns or same-sex marriage, the things that tend to come up, generally those are challenges to state laws. And so even in the Bruin case, which we'll talk about regarding the right to bear arms, sure, it's a Second Amendment case, but it's really a 14th Amendment case because that's how that right applies to the states.
And one more bit of housekeeping before we jump into the cases. The concept of stare decisis, or I think literally means let
the decision stand.
Let's stand by things decided. How does that weigh in on the court? It effectively says, we need to look to the past. A lot has been alleged that in confirmation hearings, those who have said they believe in stare decisis and then changed their mind. Your book, I think, was very useful in saying, while it's a principle, it's one that everybody seems to have violated. I don't know if that's the right word. Say more about stare decisis.
I think the only two justices on the current court who are consistent with regard to stare decisis are Clarence Thomas and Elena Kagan. Thomas, I'm answering the question backward because I haven't defined it yet. I'll get to that. But Thomas basically always prefers to get the law right, forget, how disruptive overturning the precedent might be. And Kagan, I don't think ever votes to overturn precedent, probably because she's always had an eye on Roe v. Wade. That's how this concept is often has been viewed through that lens. But it's the idea that sometimes disrupting the legal architecture or the stability, social stability, that kind of disruption is greater and would be a bigger wrong than righting the wrong of an erroneous previous decision. And so this is a prudential doctrine. It's not listed in the Constitution or anything like that, but it's the idea that sometimes it's better to let erroneous precedent stand than to correct it, just because, for example, businesses have been built on those kinds of reliance interests. If you rule a certain way and all of a sudden, all of Fortune 500 companies have to dissolve, that's quite disruptive. Courts would want someone who has thinking about stare decisis would want to avoid that kind of result. And so again, Thomas doesn't care so much about that. He's the most consistent in saying, I want to get the law right. I don't care if it's a 100-year-old precedent that lots of people have relied on. I don't care if it's last term. I'm going to vote for what the right law is. Kagan says, no, we shouldn't disrupt. We should build on the previous and things like that. And everyone else is in between and is very much fair weather. That is if one of the considerations in stare decisis is how wrong was the previous precedent, well, everyone essentially, other than Thomas and Kagan, says, finds precedent that they really like to be not very wrong at all, and precedent they don't like to be egregiously wrong as the standard has evolved.
So, okay, now we've set the table. Let's get into some of the cases. Let's start with the most, let's say, controversial, perhaps, I don't know, for our listeners. So we're going to talk about Dobbs versus Jackson Women's Health Organization, which did indeed explicitly overturn the finding in Roe, which has lasted for nearly 50 years, 1973. Explain the argument, and then let's talk about the way in which Dobbs refuted the argument for Roe. I mean, again, I know these are deep topics, so these are sort of the quick explanations, but give us a quick overview.
The rulings themselves are not that complicated, and I wrote a piece in the Washington Examiner last week saying that they really shouldn't be. You can disagree with the various rulings in these big controversial cases, school choice and guns and religion and abortion, but they shouldn't be seen as radical or extreme or complicated in some way. So the ruling in Dobbs is simply that there is no deeply rooted right to abortion, as Justice Alito found in his majority opinion looking at American history, and therefore it's subject to state regulation rather than some federal baseline. I wouldn't have decided it quite that way. I think I do think that Roe versus Wade is without constitutional basis. I would have looked at things a different way in terms of, as you said, natural rights through the Privileges or Immunities Clause rather than this deeply rooted test that was put in a case 30 years ago called Glucksberg. But in any event, this even before overturning Roe and Casey, because importantly, Planned Parenthood versus Casey for the last 30 years has been the governing standard for looking at abortion restrictions and regulations. What Roe put in a trimester system and kind of a sliding scale based on viability of the fetus of when states can regulate. Casey threw that out, and it preserved the right to abortion, of course, but it put in an undue burden standard. And for the longest time, the joke that was that what's an undue burden? Well, it's whatever gave Justice Kennedy a headache, because he's the only one. He was the deciding vote, and nobody else knew what that actually meant. But this case came along from Mississippi, which had a law restricting abortion past 15 weeks, I think with exceptions for the mother's health. Curiously, that law is actually more liberal than those laws in place in most Western European countries, Germany, France, Denmark, Spain, the list goes on and on. I think only the UK and the Netherlands have more liberal, less restrictive rules than that. But nevertheless, that's Mississippi's law. The conventional wisdom before oral argument was that the court would sort of muddle through, that this court might eventually overturn Roe, but this would be an incremental step. They'd find a way to uphold the Mississippi law without overturning Roe. Well, it turns out, based on oral argument, which changed everybody's minds about how the case was going to go, and this was confirmed by the eventual decision, only John Roberts took that compromise position, as it were. Everyone else, including the advocates for both sides, said that the court had to go fully up or fully down, meaning uphold or overturn Roe fully, which was interesting. A bit of a gamble, probably for both sides' advocates, but that's what they said, and ultimately. That's what the decision was based on. First, that the right was not deeply rooted in American history, such as the modern jurisprudence regarding unenumerated rights requires that kind of analysis. And second, principles of stare decisis do not militate for maintaining Roe and Casey, despite their lack of constitutional foundation. The dissenting justices, the three more liberal ones, to use that shorthand, argued mostly on consequentialist and stare decisis grounds, basically saying it would be too much of a disruption after 50 years to overturn these precedents.
As a constitutional matter, there's a lot of people who are concerned about this in the most extreme decision, if it is indeed entirely left to the decisions of the states, the health or the life of the mother. I'm careful it's not actually the health, or it is indeed the life of the mother. Is that constitution protected? In other words, does the Constitution recognize an absolute right for mothers to save their own lives in a life-threatening pregnancy?
We'll see. I'm sure there's going to be litigation over this, because we've already, less than 2 weeks after the decision came down, or I guess now it is exactly 2 weeks since the decision came down as we're recording this. The states have done all sorts of things, and I don't know if there's any law that's been passed that does not have an exception for the life of the mother. But that would be, it's not that there won't ever be litigation now that Roe is overturned, if states acted arbitrarily or applied their restrictions unequally in some way, whether based on race or based on some other arbitrary consideration, then that would be subject to litigation. Or what about fetal abnormalities? Or what about there's definitions that legislative drafters in the various states could make errors or not foresee fully certain things. There was a hubbub a few months ago, I think it was Missouri or somebody, was the way that their draft legislation worked didn't even allow abortion for ectopic pregnancies, that is implantation in the fallopian tubes, which are non-viable and by definition life-threatening. And that was a mistake. That wasn't I don't think it was some moral judgment that some extremist lawmaker was putting in. They just didn't draft it correctly. So we'll see litigation based on the way that different restrictions work.
And I don't want to dwell on this case, but just one more issue. The Thomas concurrence went a step further in saying this right didn't exist, and it was predicated on I don't know if you would call it an imaginary or a conjured right of privacy in this case, that those other so-called privacy-related rights in more modern cases, those that relate to interracial marriage, gay marriage, right to contraception, those things that have been found to be constitutionally protected, it may undermine the foundation of those rulings and perhaps jeopardize those as recognized by the Constitution. Do you see that? Is that an outlier? Is Thomas, or is that sort of a true, let's say, originalist view of these kinds of privacy-oriented rights?
I think it's not an outlier to criticize substantive due process because of the way the jurisprudence has evolved. It's much more constitutionally sound to protect most substantive rights through the Privileges or Immunities Clause than the Due Process Clause. The Due Process Clause isn't entirely procedural. So a well-functioning, transparent kangaroo court still violates the Due Process of Law Clause, but the way that the jurisprudence has evolved, Thomas is quite right to say that, for example, Roe itself, which was based on an earlier case, Griswold, regarding the right to contraception, found that right to privacy not in the Ninth Amendment or the Privileges or Immunities Clause. There was a concurrence by Justice Goldberg about the Ninth Amendment, but it was about how certain parts of the Bill of Rights have emanations that overlap, making penumbras, this very kind of physics-heavy, like light beam analysis, and these rights are hidden in those penumbras. That's the legal term for that analysis is hogwash. So I to the extent that that's what Thomas is saying, I fully agree with that. Now, the consequences for the application of the right to privacy or some of these other things, that's unclear. Thomas himself, I'm sure, would uphold some of these rights on an equal protection basis. He himself is in an interracial marriage. I'm sure he's not trying to invalidate his own marriage, but the things like that, or same-sex marriage for that matter, I think are more faithfully argued and protected under equal protection than a substantive rights protections. Other things like contraceptives or private sexual behaviors, say, my own view is that privacy is certainly protected in various ways, but substantive due process, I think he was correct to identify the weakness there. But for practical purposes, you have to note that the majority, written by Justice Alito and joined by Justice Thomas, joined by 5 members, not Roberts. He only concurred in the judgment, but the Alito's opinion did say that for various reasons distinguished abortion from everything else, because with abortion at a certain point, there's a second life in being. There's a second human who has rights. What that point is, he says, courts, judges, lawyers aren't equipped to point out, which is why he sent it back to the states. But unlike with all these other activities with consenting adults, here there's a second second life in being. And finally, I don't think there's the most recent polling about contraceptives shows a desire to ban contraceptives to be in the low single digits in America.
Indeed. I don't want to dwell on that, so let's move on. Another important case, Bruen. We actually had an entire episode of Hubwonk on Bruen. We talked with your former colleague, Trevor Burrows, about the issue. I just want to ask you, in your view, did the ruling, I think it was a 6-3 decision, did it follow along the originalist versus consequentialist? In my reading of the dissent, it just said, look, if we don't do something about guns, a lot of people die. It didn't really appeal to some sort of constitutional weakness in the Bruen case, but rather just sort of an emotional appeal to the consequences of upholding Bruen.
That's exactly right, Joe. Unlike Heller, the previous Second Amendment case in 2008 involving the right to keep guns at home for self-defense, where both Justice Scalia's majority opinion, Justice Stevens's dissent were dueling originalist opinions. Here, Thomas's, for the majority, And this, by the way, we can talk about this. I think this is really the term where, after 30 years on the bench, finally Clarence Thomas is at the apogee of his powers because he's the senior associate justice. And so in cases like Bruin and Dobbs, for that matter, where the Chief Justice isn't fully on board, it's Thomas who's either writing the opinion as he did in Bruin or assigning it as he did in Dobbs. But Thomas's opinion is very originalist, and Breyer's in dissent is not. It is consequentialist, as you said. So it's different than what Stevens's was in Heller 14 years ago.
So again, I want to move on then to the West Virginia versus EPA. I found this very interesting. Didn't get a lot of press, but it's something we talked about in our earlier episode, talking about at what point, when Congress delegates power to an executive agency, at what point is it obligated to define the limits of its delegation of power? I'm going to use the layman term and sort of paraphrase. I think the essence of what you said is, the more important the issue or the larger the mandate, the more the obligation to define that in the delegation. Meaning, you can't just give away huge powers in small ways. You have to be clear. And I think the Supreme Court decided against the EPA when regulating power plants. Say more about what your view of that decision was.
Yeah, this opinion did get some press. It was decided on the last day of the term, an opinion by Chief Justice John Roberts, and he paired it with another opinion in an immigration case where he ruled for the administration. So he's trying to be cagey, one for the administration, one against. And the opinion said, as you were discussing, that for what are called major questions, Congress has to be explicit if it's giving that kind of awesome power to an agency. What the government here argued, starting with the Obama administration and now with the Biden administration, is that if you look at several provisions in the Clean Air Act, and you kind of almost like that penumbras and emanations in the abortion context or the privacy context, if you put these various provisions together, that gives the EPA the power to regulate in this novel way, even though it's hugely economically significant. And the court rejected that because for regulations that of major questions, whether in terms of economics, in terms of social impact, or what have you, Congress really does have to speak clearly. We can't just assume or defer to an agency's interpretation of its own operative statute in that way. And it's interesting. The court did not, as many expected, apply or discuss what's known as Chevron deference, which is deference that judges give to agency interpretations. It simply said, we don't even have to get into that because the statute is silent, and we're not going to implicitly read in these major powers in major questions. Justice Gorsuch wrote a concurrence joined by Justice Alito that expounded more about giving guidance to lower courts about what a major question is. And that's an important concurrence because those two, Gorsuch and Alito, were on opposite sides in a case called Gundy a few years ago, which used yet again a different doctrine called non-delegation. They were on opposite sides of applying the idea that Congress can't delegate legislative power. But here on major questions, which is kind of the flip side of non-delegation, they were together. So clearly the court is, without having to get into some of these other doctrines, using this major question doctrine to limit administrative reach. And so throwing the ball back into Congress's court and saying, if you really want to have this awesome, major, significant, controversial clean power plan in place, you're going to have to legislate it and take the political hits yourself.
Indeed. Again, going back to some of the themes in your book, it's really Congress ought to be doing its job and legislating, and the executive branch ought to be executing those laws. I read the Kagan dissent, and it was really chilling in that it's the essential argument for supporting the EPA was EPA is full of experts and Congress doesn't know very much. So experts should be running the show, not elected officials.
As well as the kind of Obama pen and phone argument that when Congress won't act, I will. This is too important an issue, not to have this lawmaking on.
Indeed, yeah, I heard my Kennedy School professors applauding Kagan's point of view, but it's not one I share. So we're running out of time. I want to jump into the final. These are sort of the tension of religion. In one case, it's in a school, and the other, well, they're both school related. One where the football coach wanted to pray after a game, Kennedy versus Bremerton School District, and also the school voucher in Maine that could be applied to religious schools. I think let's just dilate a little bit and sort of talk about this idea of we, in the First Amendment, we don't want to establish a religion, but we also want to respect the practice of religion. So share with our listeners, where is that tension resolved? How does the state protect your right to exercise your religion without being seen to be establishing that as a religion?
Basically, where the court is going is that religion does not have to depart the public sphere. As long as the government isn't coercing people towards a particular religion or religion in general, as long as it's not discriminating against people, whether that's in terms of students in public schools or other contexts who don't adopt a particular tenet, then if people are acting in their private capacity, then the government isn't going to stop that. And at the same time, when it has institutes programs, it can't treat religious institutions differently than secular ones, which is different than this was discussed in the Kennedy versus Bremerton case, the praying coach, the Lemon test from a case called Lemon versus Kurtzman 50 years ago that talked about an entanglement of religion, an entanglement of government with religion that effectively had been read to negate any religiosity, any exercise in the public square. Justice Gorsuch in the Kennedy case said that Lemon had long ago been abandoned, and indeed it hadn't been used by the court as a governing doctrine in a long time. All the juice had been squeezed out of the lemon, so now they were discarding the rind, if you will. And conversely, with the school choice case, or when Maine created this program of tuition assistance and said parents could use it to send their kids to any school of their choice except religious ones. And the court said, look, you don't have to have this kind of program, but if you do, you can't treat religious schools differently than secular ones. So that's where we are on the state of religion. And I think it's tremendously overwrought to say, as a lot of media commentators did, or as Justice Sotomayor did in her dissent in Carson, that this eviscerates the division between the separation of church and state. The separation of church and state itself comes from a case in the early 80s called Everson, an interpretation of Everson's line from, I think, the 40s or 50s, and it's more complicated than simply saying, religion can't enter the public sphere and the public sphere can't enter religion.
So we're getting to the end of the show. We would be remiss if we didn't mention that we're getting a change of justices in the new term. We're losing Breyer, who is retiring, and we're getting the newly appointed Ketanji Brown Jackson as his replacement. I think they're both regarded as, again, we shorthand is liberal justices. How do you think her joining the court will change, if at all, how the courts will decide cases?
I don't know if I can, off the top of my head, identify cases where she would vote differently than the justice she's replacing, her former boss, Stephen Breyer, for whom she clerked. So in terms of vote count, I don't think things will be very different. You have different specializations. Breyer was famously an administrative law specialist. I'm not sure whether Justice Jackson really carved out a niche for herself in terms of substantive areas of law. And as Justice White used to say, every justice makes for a new court in terms of their internal dynamics. How convincing will she be? How in terms of the social dynamics behind the scenes, which don't necessarily affect justices' votes on major issues, but they can affect the way they interact and the dynamic of the court more broadly. Will she, turn off Chief Justice Roberts and in effect marginally have him closer to his more conservative colleagues? I don't know. I think in the short term, we're not going to see that much of a difference, other than in oral argument, the absence of Justice Breyer's kind of long, meandering, multi-part hypotheticals and those kinds of opinions that he was known for with kind of a pragmatic multi-factor balancing tests.
So it would be less about her judicial capabilities or her wisdom, but rather her salesmanship, how she can influence others either to her position or not alienate others away from her position. That would be more influential than perhaps the how she decides a particular case.
I think that's probably right.
All right, we've run out of time. I appreciate you being with us. Now, one last chance to plug your book before we go. I think it's a must read for those who want to pretend to be constitutional scholars at cocktail parties. Where can our listeners get your brand new paperback book?
Sure. I mean, you can go to Amazon, of course, but you can also type in supremedisorder.com, and that'll give you lots of options of where you can get it beyond Amazon, independent booksellers and whatnot. And also there, you can download for free a 20-page statistical historical appendix of all Supreme Court confirmation battles, as well as some lower court ones in the modern era. And in addition to my book, I have my new Substack to plug. This is a digital platform, digital newsletter. It's called Shapiro's Gavel, and there you can subscribe for free. I've committed to at least one post a week, and I'll have other stuff for paid subscribers. There's going to be additional goodies. It's it's reader supported, as they say. We'll see where that takes us. It's an interesting thing for thoughts and musings and analysis that I wouldn't necessarily write up in the pages of the Wall Street Journal or Newsweek or the Examiner.
Perfect stuff for those of us who are Ilya Shapiro groupies. So thanks for that plug. So we're at the end of our time together. Thank you again for joining me, Ilya. It was great. And I really do wish you luck at your new home at the Manhattan Institute.
Thanks very much. I'm come back from vacation, tanned, rested, and ready to be in the arena.
This has been another episode of Hubwonk, a podcast of Pioneer Institute. If you enjoyed today's episode, there are several ways to support the show and Pioneer Institute. It would be easier for you and better for us if you subscribe to Hubwonk on your iTunes podcatcher. You can now find Hubwonk on YouTube at the Pioneer Institute channel. If you want to make it easier for others to find Hubwonk, it would be great if you offer us a 5-star rating or a favorable review. We're always grateful if you want to share Hubwonk with friends. If you have ideas for me or suggestions or comments about future episode topics, you're welcome to email me at hubwonk@pioneerinstitute.org. Please join me next week for a new episode of Hubwonk.